Moving on to understanding Article 21 of the Constitution of India. Article 21 of the Constitution of India is probably the most important article in the Constitution itself, apart from being the most important article in Part 3 of the Constitution relating to fundamental rights. Article 21 talks about protection of life and personal liberty. It says something like this: no person shall be deprived of his life or personal liberty except according to the procedure established by law. So, if one reads Article 21, it says that protection of life or personal liberty, there are two components of it. So, personal liberty is slightly different from protection of life. So, personal liberties are your freedoms, your what human beings aspire in terms of liberty of thought, process, belief. And the second part is the right to life, which means every citizen has this kind of a right which cannot be taken away by the state, however, except by the procedure established by law. So, Article 21 is probably been the most important provision in terms of protection of citizens' right. And you will notice that there are a lot of case laws and judicial review that has happened uh, in what do we mean by what is stated in Article 21. So, uh, first, let us understand how the judiciary has viewed this article. In the 1950s, in a case called A.K. Gopalan versus State of Madras, the Supreme Court had taken a very narrow interpretation of Article 21 because it had held that the protection that is available under Article 21 for right to life and personal liberty is only available against arbitrary executive action. This was a kind of a limited interpretation, which meant that if your right to life is curtailed by legislative action, which is by a law, then you cannot approach the courts and you cannot claim that there is an infringement of Article 21, which means in A.K. Gopalan, the Supreme Court gave the legislature and the law that is made by the legislature the right to decide the elements of life and liberty and when such elements of life and liberty can be curtailed. However, when it came to 1978 in the Maneka Gandhi case, I think things changed, as I had discussed earlier. Things changed because of the 1975 emergency. Things changed because the judiciary wanted to uphold constitutional values and constitutional freedoms. The judiciary was asserting itself from legislative and executive interference. So there was judicial activism at this point of time, very in terms of very prominent processes that could have been laid down. And what it meant is that when emergency was imposed, a lot of people were arrested arbitrarily. That was through an executive action, but emergency imposition itself was a kind of a law-making, power. And to challenge the imposition of emergency and what were the rights available during emergency and how much of life and liberty were curtailed because people were arbitrarily arrested due to the emergency law. Many of the writs were suspended, like writ of habeas corpus and so on and so forth. And hence, to be honest, whether emergency was constitutional or not probably could not have been tested if someone went by the A.K. Gopalan's judgment. However, you will notice that when it came to Maneka Gandhi case in 1978, the Supreme Court of India said that the A.K. Gopalan case is not a good law. They did go in for a wider interpretation of Article 21, and they ruled that the right to life and personal liberty of a person cannot be deprived by any law uh, unless that law is reasonable, fair, and just. So the executive action is already to be tested under Article 21. However, the Parliament or the legislative action will also be tested if it violates life and liberty of citizens. So, if the law is just, fair, and reasonable, then to that extent, the procedure established under that law can, to some extent, curtail your life, curtail your liberty. And that's why Article 21 says you have right to life and personal liberty, but they can be taken away by procedure established by law. So, what did the Maneka Gandhi case do? Is that it laid down a fact of what was very well understood in the American Constitution, which uses the word due process of law, and which means that if the law establishes a just process, then life and liberty can be curtailed to some extent. They can be, restricted, deprived, but not otherwise. And that due process of law means the law would be just, fair, and reasonable. So I think borrowing from the spirit of the American Constitution, and the Indian Court did lay down the emphasis on procedure established by law. That's one part of the Maneka Gandhi case. But however, please note, due process and procedure established by law have some distinctions. But broadly, that was how this was laid down or brought into existence. And also, it means very clearly that the expression procedure established by law, uh, though is quite differently used under the Indian Constitution, it only means that you not only have liberty of the body of the individual but also of the person's thought and processes, and that I think is quite relevant and important in understanding the ambit of right to life under Article 21. Further, what the code does is also very significant. It says it defines the meaning and purpose of right to life. It says it is right to life with human dignity. It's a life that is meaningful, complete, and worth living. So that is what life would actually ordinarily mean. So having the widest expression and widest implication of both life and liberty, the Supreme Court, gives a new dimension to the reading of Article 21 in the Maneka Gandhi case. Now, having said all of these, you will notice that today, right to life and personal liberty has been discussed by the Supreme Court in lot of cases, in understanding what is this meaningful life, what is this life with dignity, what is this life that is complete and worth living, and when can state actions which deprive a meaningful, dignified, complete, and worthy life be interfered with, and when it should not be interfered with? So, if you notice, the courts have said, for example, in the state of Bihar versus Subhash Kumar, they have said that the right to environment, they had qualified this. Initially, they said right to environment, but now they have said it is the right to clean and healthy environment is a fundamental right under Article 21. So, life includes a decent environment, it includes pollution free water and air, and it also means protection against hazardous industries and activities. Further, I think the courts also have dealt upon aspects like the rights of an AIDS patient and employment. This was the case of Mr. X versus Y, and there was a case of ZY in Bombay in 1997, where a person cannot be regarded as medically unfit and cannot be denied employment merely on the ground that he was found to be HIV positive. So, any kind of discrimination of employment affects right to life is what the court held in this Mr. X versus ZY judgment of 1997. Which means livelihood is actually the most important aspect of life, and a person must be entitled to gainful employment and also take his livelihood uh, uh, as a matter of right to life. Uh, Now, if you look at some of the cases of the violation of right to livelihood, you would notice that a lot of people, have been ignored of their, say, contractual rights sometimes, where their contractual employment has been terminated unreasonably, unfairly. So it affects your livelihood. A lot of people have been displaced due to land acquisition, and this was something that happened due to the Land Acquisition Act of 1894. and without any compensation, without any resettlement or rehabilitation. Does it affect right to livelihood? In the Narmada Bachao Andolan versus State of Madhya Pradesh 2011 Supreme Court, the court did held that if someone is displaced and the state is not sensitive enough in providing compensation, rehabilitation, and resettlement, then it amounts to violation of livelihood of individuals. So I think the courts, in terms of livelihood, have come up with a lot of interpretation under Article 21. Moving forward, the right to privacy, which I think in current times has gained a lot of significance. Very recently, we found the Parliament passing the Personal Data Protection Act. Uh, Thanks to the cases that have been decided with the Supreme Court, in which it has said that right to privacy is integral to right to life. It is integral to Article 19, which ensures your freedom. And interestingly, while right to livelihood is a very positive right that you can claim from the state that it should not be infringed and you are entitled to livelihood, right to privacy can be inferred as a negative right. It's sometimes called the right to be left alone. It is the right in which you want the state not to intervene in that case. So, interestingly, the first among the cases in which right to privacy was brought into highlight happens to be the case of Kharak Singh versus the Union of India. Uh, Kharak Singh versus the state of UP. I'm sorry, that's what was the case. It was a case of 1964, and in this case, what had happened is the petitioner was accused of dacoity, but later on he was acquitted because of lack of evidence. However, the Uttar Pradesh police insisted on surveillance of the petitioner, and this would mean that his house would be visited by the police in the night, and he was asked to periodically come and put his haziri in the police station. His movements were tracked, and so on and so forth. So, the UP police, despite that he was acquitted and there was lack of evidence of his involvement in dacoity, continued to do surveillance of the petitioner. The petitioner filed a case challenging the constitutional validity of the state action, and the court in this case, holding that there is something called right to personal liberty and there is a right to privacy, held that restrictions on one's movement uh, can be only placed in the rarest of rare circumstances, if it's so necessary for the security and interest of the state. If not, any such actions of the police would encroach on one's private life. See, visiting someone's house in the night is definitely a violation of privacy, and personal liberty is something that has to be protected at all circumstances, at all levels. So, I think right to privacy has gained a lot of significance and traction. You will notice that quite recently we also had a nine-judge bench of the Supreme Court, which in Justice Puttaswamy case again reiterated that there is right to privacy as a fundamental right under the Constitution of India. Now, the Justice Puttaswamy case is important and interesting for the simple reason is that today we are in the era of digital information or we are in the era of internet, and internet tends to invade a lot of privacy, and this kind of a invasion of privacy can happen not only by the government but also by the private sector. And hence, the issue about what is the scope, extent, and definition of privacy in the internet world was discussed by the Supreme Court in the Justice Puttaswamy case, and they did hold and reiterate once again that this was an essential part of the freedom of personal liberty, and they went on to state that it is the duty of the state to protect privacy, and it is the duty of the state to also provide for a law for the protection of data that is personal in character and nature. Please note, privacy of an individual and privacy of institution can be two categories of privacy, but nevertheless, I think privacy is now enshrined in the constitution, and I think globally, thanks to the European Union passing a law called the General Data Protection Act. It is called the GDPR legislation. I think globally the discussion on privacy has taken a lot of traction, and in India as well. I think we find that the law casts a duty on anyone who collects personal information to keep that information in a fiduciary capacity with trust and confidence, not to divulge this personal information to any third parties, not to use data as a commercial kind of a property and venture. So when you collect personal data, you have to protect it. You have to have enough cyber security measures so that it is not breached or leaked and someone does not misuse the same. So I think that kind of right to privacy is also something that is brought about under Article 21 of the Constitution. The next right is right to shelter. This is definitely important. It's quite an interesting thing about why shelter is important, because if your life has to be meaningful, you need the shelter. You need the roof on your top. And the right to shelter was enshrined in a case called the Uttar Pradesh Vikas Parishad versus Friends Cooperative Housing Society. It's a 1996 judgment of the Supreme Court. Because see, what happens with shelter is tenants are dislodged or displaced immediately on notice of the landlord without having an alternate place to live. So all of these become critical issues, and there are various aspects of your life, livelihood, and personal liberty, and one will have to actually take due care while deciding right to housing, right to shelter. These are very important aspects. Right to health is also very, very critical and important, and right to life. You need a healthy life, and who has a duty to provide you health so that your life is meaningful, it is dignified, and it is healthy. I think it's the state, but it is not only the state. Now, you will notice that the courts have extended right to health also to say and suggest that such kind of a right has to be protected even by private medical institutions. They have to be respected also by doctors who are duty bound to give you emergency medical treatment or medical aid without any kind of expectation of consideration or commercial price. uh, if you're a doctor, you have taken the Socrates oath. Socratic oath is very, very critical and important to save lives. So doctors have a duty, the government also has a duty, institutions also have a duty to ensure that right to health of citizens are adequately protected and they are not infringed in any adverse or other manner. Please note, in cases like the Parmananda Katara case, it so happened that because of these kinds of accident cases, hospitals were very hesitant to admit patients, because it becomes a medical legal case. You have to call the police. Unless you call the police, you cannot start emergency treatment of the patients. In some cases, hospitals reject. They don't give first aid. They don't give emergency care because they fear police action. They fear that you will be called to the court to depose as witnesses and so on and so forth. So there is a lot of kind of a harassment that the doctors and the hospitals face, due to which they hesitated in admitting patients and giving them first aid. The Supreme Court changed this whole scenario, declared right to health as a fundamental right against both state and non-state actors. It ensured that hospitals will not reject patients, especially till they stabilize and give them fair, treatment of emergency and first aid. So the court comes to that, kind of a level to alleviate the sufferings that people have done due to accidents or due to emergency medical treatment. And right to health was declared as a fundamental right under Article 21 of the Constitution. What is critical here is also to understand that whether right to life includes right to die. This was a very interesting question that was laid down in a lot of cases. Uh, like the P. Ratinam case, and most importantly, in the Srimati Gyan Kaur versus the state of Punjab case that was decided in the year 1996. Now, committing suicide, is kind of taking your own life. There are various means in which it can be done. For example, you take your own life or you ask the doctors to do it. It is called euthanasia. And whether right to life can include right to die. So initially, the courts did say yes, right to life can include right to die. So if you want to take a samadhi, you want to sacrifice your own life in terms of, say, locking yourself and not eating food or going on a hunger strike and so on and so forth. The court said, okay, fine, it's right to life can also be negatively inferred, meaning right to die. But in the Srimati Gyankor case, I think the court had a concern about the fact that, look, your life is not your own. The state has an interest in your life. There are families that are dependent upon your life. If we start saying that right to life also includes right to die, then that would result in a negative understanding of the concept. Life is to be lived. Life is positive. Life is about gaining and fulfilling the expectations of life. So you have to have positive thought and mindset when it comes to the constitutional dimension of life and personal liberty. So, giving someone the right to suicide as a part of Article 21, the courts did not agree with that. Uh, However, the courts in cases like the Aruna Shanbag case have said that euthanasia is possible in critical illnesses where someone is in a vegetative state and is unable to recoup or come back. Then, can the doctors decide to do what they would like to prefer? Because doctors don't like the word euthanasia, they like the word end of life care. So, taking away the life support system and taking a call on someone's life at such critical junctures, can the doctors and the hospitals take a due care of the same? I think what the Aruna Shanbag judgment and the subsequent judgment has said is, in India, we can probably do what is known as passive euthanasia, but not active euthanasia. Active euthanasia involves someone being injected with something so that he dies, or someone being given some kind of a drug so that his life is taken out. That's an active euthanasia. So the doctors actually assist in your death, and they do an active assistance in your death. That kind of euthanasia, the courts have said, is not something that is permissible and should not be encouraged at all. Because in the legal system that we are currently right now, we are not so mature enough, or we are not so advanced that this can be provided for, and this could amount to a lot of misuse and abuse, not only by the citizens who wish to take their life, but also by the hospitals and institutions. So the checks and balances will be absent in those cases. Um, However, in passive euthanasia, I think a team of doctors, and if the judiciary, through a judge, kind of decides that this is a fit case for committing euthanasia, or what we call as end of life care, then a team of three doctors along with the judge can come to this rightful conclusion, and the person can be relieved of his final journey. And such kind of passive, which I said, removing the life support system and so on and so forth, may be taken. However, again, while this is a judgment, the cases where such euthanasia have been committed are not so very common for us to discuss or understand, but it is constitutionally recognized, and that is also part of the jurisprudence on right to life. Right to free education, we'll take this up, of course, well before Article 21A was introduced, right to free education was also there. Right to free legal aid, I think this is an essential part of right to life and personal liberty of accused. See, legal aid is something that every person who is unable to access justice is entitled to. Now, the judiciary has stepped up this kind of a right of free legal aid by establishing what we call as the Legal Services Authority, both at the state level, at the district level, and then finally at the national level. This authority is usually headed by a judge, very senior judge, and a list of those people who want to be represented in the court, and they cannot access the court, they cannot access the justice delivery system for many reasons. It could be financial or otherwise. Then the Legal Services Authority will appoint lawyers as defense counsels who will actually represent the accused, and they will probably take their case and cause before the court of law. And this also becomes essential part of right to life of an accused, because an accused should not languish in the jail as an under trial. He has the right to come out on either bail or get a speedy trial. So the right of both speedy and fair trial is also a right of life. Speedy and fair trial. So that can only be ensured if legal aid reaches those marginalized sections of the people who have wronged the law, nevertheless, who have the right to get or seek justice from the court of law. Right against solitary confinement. This was a kind of a colonial punishment that the jailers were used to. Just because you have been a convict doesn't mean you should be in solitary confinement, which means you don't have the right to socialize, talk. The very basic aspect that even a convict has rights and the convict has the ability to socialize was recognized in this case, and such kind of treatments of solitary confinement in jails was abandoned. The court intervened and said this is something that has to be stopped. And I think in the criminal justice system, some of these reforms have helped establish the dimension of human dignity, even to a convict, even to an accused. Right against handcuffing. Unless there is a threat that the accused is going to escape, or if the accused causes any danger to public life, he shall not be handcuffed. We know this thing of handcuffing was quite a common practice for every kind of an accused. But the court said that is totally unnecessary because, again, it is not a dignified way of treating an individual. And all individuals, just because they have been accused, does not mean they are hardcore criminals, and they are a threat to the society. So, the right against handcuffing was also something that was pronounced by the courts under right to life. Right against inhuman treatment. Of course, there are so many first degree, second degree tortures which are done by the police and by the jailers at time in the prison and in custody. Sometimes they, have this tendency of misusing the power because they're in the four walls of the police station. So any kind of inhuman treatment which results in any kind of an injury to an individual in custody would entitle him to get rights, and this is a violation of his right to life, because I think inhuman treatment cannot be administered in any democratic society. So the democratic value is that you have dignity even in death. Forget dignity of an accused, and hence anyone who actually infringes the same, especially the state of the police, are entitled to be punished for the infringement of right to life. Here I am reminded of what we call as the sanitation workers, or what we call as manual scavenging. uh, Manual scavenging is a prohibited activity, employing people to, clean your toilets or your toilet drains. Is completely now prohibited by law. You can only use mechanized systems because a lot of lives were lost. So, a particular section or caste in the society were working as manual scavengers. So, treating them in such kind of inhuman manner has been now prohibited by law. Employing these individuals for manual kind of such work is considered as inhuman treatment, and hence you will notice that that is also now some kind of an activity that India and the Indian Constitution does not encourage. Rather, for the employing of such manual scavengers, there is a punishment that is prescribed by law, and it's a criminal punishment. It's a criminal offense because you are actually mistreating human beings and employing them for such kind of jobs.